So today we're going to discuss copyright in more of a traditional sort of lecture format here, just using some PowerPoints to kind of go through and hit some key topics. It's important to note rather, that what we're talking about today is, of course, the United States copyright, but the issues here really are pretty similar among most countries, and as we'll discuss here in a slide or two, that there definitely is cooperation between countries. Now, right now, to start off, copyright is a United States constitutional right, and it's actually built right into the Constitution. And basically, the founding fathers wanted to secure a way to make sure that people were innovating, and they thought that if they didn't protect copyright, then there'd really be no incentive for people to write, novels, or create other sorts of arts, to create invent new things. And so this has been a part of our country since we've had a country, and that's important. And especially as we think about, today, copyright is the power of the copyright seems to be eroding somewhat, and basically, the internet has made it so easy to share that people they expect free. They think that it's okay. And here we'll discuss later in the class that it's not always okay, and there's a long-standing history of it. It's not like this is a new concept. Anyways, the current law states that copyright is established at the time of creation. So again, I'm a photographer, so as soon as I snap that shutter, boom, that's a new copyright. If you're an author, as soon as you start writing things down on paper, or obviously today much more likely, as soon as you start typing that into the computer, that's a new copyright. And it doesn't matter what you're creating, really. It's all intellectual property. If you are creating something that is unique, and again, getting back to the photography, I could stand in a certain position and take a picture of the Columbia River a certain time of day. I could take one step over, somebody could take one step over, so that they're taking the exact same composition, same camera, virtually the same time of day. Taking that picture, it will look virtually identical. That's still going to be two separate copyrights. So that's worth pointing out. We'll talk about plagiarism later. That kind of relates to the whole you can do the same thing, but maybe not exactly. So here we go. Current copyright law, as we know it today, was more or less established in 1976, and as I mentioned to start, the idea of it goes way back to the founding fathers, but that doesn't mean it hasn't been refined over and over and over again. The current version that we're working at here in 1976, basically at that time they said you don't have to register your copyright in order to obtain a copyright. So before that, if you didn't register, you didn't actually have the copyright, even though you had the right to have that copyright, if that makes sense. Even after 76, if you don't require, even though it's not required to register, if you don't register your work with the U.S. Library of Congress, then you won't receive the full benefit of the law. And we'll talk about that coming up. In '89, the United States joined by signing the Berne Convention, and for the protection of literary and artistic works. And this is important because this is basically what makes copyright respected from country to country. So if for example, one of my books has been appropriated for somebody took some of the images out of that, and they've been making silkscreen T-shirts in Taiwan, or not Thailand, excuse me. Because of this convention here, when I tell this person you need to stop doing this, then they absolutely have to. And if they don't, then they are subjected to the same sort of punishments that we have here in the United States, even though the infringement was done in Thailand. So this is very important. It also importantly eliminates the requirement that all copies carry a copyright notice. Now that doesn't mean that it's not a good idea to do that. If you have a book, again for the example, right in the beginning on the title page, you know, copyright so and so, and if you have a photograph, you can put a watermark on that, you know, 2000, you know, copyright 2013 Michael Cloth, all right reserved. Still a good idea, but you don't have to do that, because that not only is the creation of that copyright automatic, you don't now have to state that in order to have full benefit. And again, all countries respect the copyright where it was created. That's important. 98, Sonny Bono, which of course, you know, he had a stake in this as a musician before he was a senator. He introduced the copyright extension 98. Basically, so now anytime that you create a copyright, it is yours or your estate's for up to 70 years after death of the creator. Now that means that of course your heirs get the copyright after you die, and so it's important if you create something of value to actually pass that on in your will. But there's also, you know, that's the general. There's other things that kind of confuse it, that might extend this even beyond that. Yeah, Walt Disney is a good example of how there are exceptions. Sorry, I had to pause there for a minute while the jets go by. Part of the fun of living too close to an Air Force base. So anyways, left off, the next one here is the Digital Millennium Copyright Act, DMCA. This is one, it was actually the same year, is also, well, they're all very important, but basically what it introduced is it made it unlawful to tamper with copyright management systems. So if you put a copyright notice on a photograph, for example, and somebody crops it off or covers it up or something like that, that is illegal. It also gives safe harbor to internet service providers. Now this is very, very important in today's in today's atmosphere. Without this, sites like Facebook wouldn't be allowed to post a single picture, because that would put them liable for every infringement. And let's face it, there's lots of stuff that people post that they don't actually own. And so by giving them safe harbor, the flip side of that is that once somebody says, hey, that's a copyright infringement, they have to take that material down immediately. And they take that down, and then they can do the due diligence and make sure that yes or no, it may or may not be infringement. But as soon as they're notified, they have to take that down. Otherwise, then they do become liable. So basically, you know, the copyright belongs to the creator unless the copyright is specifically transferred. So you know, you could write a book, and then you could say, okay, here, I give you full permission to have a copyright of it to you know, your friend or whatever. If it was made for hire, so as a photographer, somebody might hire me to create a photograph under the made for hire. So basically, even though I would normally have the copyright, if that specific made for hire phrase is in the contract, that means that the person hiring me would own the copyright instead of me, or if it's created by an employee. So you know, if you work for, let's say, you know, Microsoft, and you create this novel new piece of software that everybody's going to love, well, guess what? Microsoft owns that, not the employee who came up with the idea. There are exceptions, but this is the general rule. And in order to be an exception, it needs to be written into the contract. And basically, that's what we got here. Legal contracts, they'll protect you, and you need to do that. So anyways, it protects, copyright will protect the particular way that the authors express themselves, and that's important because, and we'll show some examples here coming up, but basically, getting back to that picture at the Columbia River, the exact photograph that I would have taken there was copyrighted, but not the idea of it. So as soon as I clear up all my gear, my tripod, and move on, somebody else can move in there and take virtually the exact same picture. The idea behind that picture is not copyrightable, but it's the actual work itself that is. And of course, I've already mentioned this, registering your work with the Library of Congress, and now you can do it all electronically on their website. It affords you extra protection, and the extra protection is important. First of all, if your work is infringed, you have to register it. Either, hopefully you did it before the infringement, but even if you decide that you're going to pursue it after it happens and it's not been registered, you have to file in order to file a lawsuit. But having your work registered before an infringement allows you to have some very important things. So without registering, you are entitled to fair market value. And so if somebody stole one of your photos, then you might be, maybe you're entitled to maybe $2,000 because they used it for a huge sales campaign, whatever. But that's all you get. And basically, that's a pretty small stick for a big company. And so somebody like, let's say Fox Broadcasting, and they've actually done this, like for example, like during their football games around Christmas time, they'll post pictures of the areas where the games are going. Almost certainly those are copyright infringements because they don't pay for that use, and they take them off the website. But because almost nobody registers their work, or not nearly enough rather, what's the worst that can happen is they have to pay the person that they stole the work from. And really, when you have a big corporation, it's kind of a David and Goliath kind of thing. You're not going to go against it. Now, if you register, you get statutory damages and legal fees. So, no register, you can't even hire a lawyer without making things worse, because you're paying those legal fees out of pocket. Statutory damages, if you win within registered, you not only have legal fees that'll be covered by the infringer, again, if you win, but you're also entitled to statutory damages. And that is a very big stick, because that can be up to $150,000 per infringement. So again, for that Fox example, if they happen to post 2 pictures by the same person, that would potentially be $300,000 had those been registered, had they actually won a lawsuit. Once you register, you get a certificate in the mail. It can take forever. They got a huge backlog. There are exceptions, and you can use it for certain things. So fair use basically has to meet these requirements. So you can use it for criticism. So basically, if you have a movie critic, you can have that person show a clip of the movie on their television show or their website, and in the context of their discussion of the movie. So that would almost certainly be okay. Comment, same sort of thing. If you had a sculpture, a public sculpture, for example, that was down on the riverfront, and you wanted to talk about how public art was improving the community, you could take a picture of that, and that could be part of your commentary, and you can use it for those kind of illustrative purposes. News reporting, obviously, the news is a big exception. You get the freedom of the press. It allows you to report and do that in a way that circumvents the copyright protection. Teaching. So obviously I've been taking pictures and videos in all sorts of things from all over the place for the sake of this course. Generally, that is protected. Scholarship, the flip side of that is, if say you are doing a thesis project, you can refer to you can refer to copyrighted material in your thesis, so long as, of course, you have the proper sort of credits to the original copyright holder. But you can include that as part of your research, of your scholarship or research. And the other thing is parody, which of course kind of gets back to the whole Gaudier video that we started with. Derivative work. This is definitely a little bit more of a muddying of the waters here. So derivative work still belongs to the original copyright holder. Of the Gaudier videos that we started off with, the last one, which was basically a remixing of the official video, chances are that one is a copyright infringement, because it is very, very clearly a derivative of the original video. It needs to be substantially different. So does that mean the Star Wars video is substantially different? Maybe. The words are different for sure. The idea is the same, but again, we already discussed, the idea doesn't have to be the idea isn't something that you can copyright. It's really more about the expression of the idea. So probably that's okay. And then appropriation. Now this is a tricky sort of one, and we discussed appropriation a bit with the Dada movement. And appropriation, chances are that's going to get you in trouble, for the same reason that all of this derivative work still belongs to the original copyright holder. Infringement. So acknowledging the source is not a substitute for asking for permission. This is a thing that we see all the time with professional photographers. This is kind of a pet peeve of mine. You get all of these new photographers who are like, oh, respect my copyright, don't go making copies, don't go using it for whatever, this and that. But then they have no qualms about posting, popular music on their website. Sorry, pause it there for another jet. So they have no qualms about posting popular music on their website with a link to the artist, and they think, well, that's helping because that I'm giving credit to the artist, and I might be introducing some new person visiting my website to their work, and that might lead to music sales. Okay, that's just not a valid argument, and that is definitely copyright infringement. Plagiarism, related, and this is obviously related or very relevant to academic settings. Of course, the Random House definition here is use of language and thoughts of another author without representing them while representing them as their own work. Basically, if you use somebody else's, this is most commonly in essays and stuff, if you use somebody else's words verbatim, you need to cite them, the original author, otherwise it is plagiarism. It doesn't have to just be written word that can be plagiarized. This isn't the same as copyright violation, but it can be. And so if you what's a good example here? The difference here is that generally speaking, and we're going back a couple of slides here, if you remember, academic scholarship and research protects certain copyright infringements, but that doesn't mean that there's not ways that you can plagiarize things outside of academics. And certainly all plagiarism is not copyright infringement, but it can be, and so I guess that's an important distinction. Common myths about the copyright law: if it doesn't have a copyright notice, it's not copyrighted. We've already discussed that. If I don't charge for it, it's not a violation. No, that's just not true. If you use somebody's music, and this is something that I see over and over and over again, as a slideshow for your vacation photographs or whatever. You're not charging anybody, you're just showing it on YouTube or you're showing it to your family. Well, guess what? That's still an infringement, even if you're not earning anything from it. If it's posted on the internet, it's in the public domain. That's absolutely not true. Most new content that's posted is going to be copyrighted. Things that are before the current copyright laws were written might very well be in public domain. So, for example, if you find the original Sherlock Holmes stories on the internet, you can probably find the full text on Google because on Google Books, because that is before current copyright laws existed. Obviously, that muddies the water a little bit because that would be a British copyright instead of U.S., but same sort of thing. If it's old enough, it's probably public domain. If it was created after current laws exist, then it can only be public domain if the copyright holder makes it public domain. People say, oh, my posting was fair use. Well, that's used without really understanding it, and really the only way to know for sure if it's fair use is to have a lawsuit brought against you and have it determined in a court of law, and that's a pretty expensive gamble there. If you don't defend your copyright, you lose it. No, that's not true. It's yours no matter what. You can do whatever you want with it. Somebody has that name copyrighted. You can't copyright a name. You can't copyright business names, whatever. Those are trademarks, so that's different. Related but different. So are patents. If I make up my own stories, base them on another's work, new work belongs to me. This is the derivative work thing. Fan fiction is such a popular thing for certain television shows, and people are like, oh, the hottie and so and so, I'm going to make up a new story based on that, where they hook up with somebody else. No, that still belongs to whoever is the copyright holder for that television show. Defendants in courts have powerful rights. This is true for criminal cases, but these are civil cases, and defendants have basically the difference is with criminal cases you have the burden of proof on the prosecutor. In defendant cases, for civil cases, that's just not true. One or the other is going to win, but it's not because the person who brings suit has any more or less of a burden than the person who's defending against it. Copyright violation is a crime. That's not true. It doesn't hurt anybody. It's free advertising. Again, getting back to that Godier video where they had the text. It may not be hurting anybody. It may be free advertising, but it's still copyright infringement. And they emailed me a copy so I can post it. This is another good one here. If you, let's say, purchase a sculpture, you have the right to display that sculpture for your own personal use. That doesn't mean that you can go and take a photograph of that and then use that to, say, promote your brand new business as a sculptor. It's still going to be infringement. If you are given something, or if you purchase something, the safe and really the only the only thing that you can assume from that is that you have permission to use it for your own personal use. Everything else needs to be in writing. Whoops. Here's some resources for you. I'll just keep that up for a second. And again, even though Wikipedia is not a great source for citing academic work, these I've included them here because they give you some pretty good overviews. And obviously these aren't things that you need to know in depth, but if you just want a real quick check on what something is, this is a good good place to check it out. So here's some examples, basically he made this poster during the president's first campaign. It became very, very widely used, and it was based off of this particular photograph here that Garcia made for the AP. Went to court. Basically, what happened is it was settled out of court because it looked like he was probably going to lose, and it was better to settle than to lose a lot of money. A little bit more about it here. The president even wrote a letter to Ferry to thank him for it. It was used in Time, Esquire. Copy actually exists in the U.S. National Portrait Gallery and Museum. Eventually, I guess one of the other things I didn't mention, originally the AP brought suit. Manny Garcia decided that he was also going to sue, but he dropped out because he said he wanted credit and compensation, but all the business society was part of the use. Well, all of this was pretty much irrelevant because he worked for the AP in a work for hire, and so he was never a copyright owner, and so he had no stake in the whole lawsuit. 2009, he said he was claiming he based his work on a different photo, and whoops, eventually he came up clean. He said no, it was based on that photo. And so not only did he copyright have an infringement, but he also falsified documents and destroyed evidence. Obviously those are big no-nos. Eventually he settled in a closed settlement. Obviously when you have a closed settlement, that doesn't mean that there was guilt, but it definitely suggests that there might be. One of the interesting things, what would he do? This is one of his original works, and it's been a number of years now, but I don't know if you remember the big SARS virus scare that was in Asia. People were wearing masks, and so Baxter created this poster here to protect. And while he was saying, "Oh no, it's all fair use, blah blah," when somebody else did it to him, he sued him. So here, another one for Andy Warhol. We've already discussed his silk screening, and we didn't use the one for Mrs. Kennedy. Same basic idea as the other ones we discussed earlier. Turns out those were based off of some photographs that were published originally in magazines, and even though Warhol was dead, his estate was sued and lost. All of this came to light. Actually, it was kind of interesting in 1995, which was a number of years after Warhol died, because the original 16 Jackies was auctioned off, and that's when the original photographer here found out that Warhol actually used his photographs for his work. And so basically Warhol's estate lost that one. Sherry Levine, another one here, after Walker Evans. This is a really bold sort of thing where Walker Evans made all of these photographs for the Farm Security Administration in the Great Depression time. And he took this picture here of a migrant worker. Sherry Levine goes to the museum and takes a picture of it. And she said, and she entitled it After Walker Evans. So she said this was her interpretation, was a completely new idea. Well, you can see for yourself. They're virtually the same picture, and that is the kind of thing that is very gray. It's a derivative work, and ultimately she lost in her or battle defending this. But you can see how in the era where concept is the art, that it would inspire this kind of creation. So here in the bottom I have the afterwalkerevans.com, and then this quote here. Quote here actually comes from the fact that somebody, and well, specifically it was Michael Mandelberg, put together a project that was after Sherry Levine, as a way to discuss these exact issues. And so the quote then, of course, is about what Sherry Levine, her thoughts on the after Sherry Levine is, and what his speculation is. So definitely encourage you to check that out. AfterWalkerEvans.com. Richard Prince, another big example here. So this is the original photograph that was taken by Krantz. It was the Marlboro Man, because it was used for an advertising campaign. Prince changed it, so obviously this is a different photograph, right? Instead of having this kind of pinkish red shirt, now it's purple. Now he's got a gray hat, and he cropped it. Richard Prince is a very successful artist in that he's very successful financially. His work commands a lot of money, and so he is also appropriating the original work. Again, this is almost certainly a copyright infringement. Where did we not go here? Here's another example of Prince's work, and this one here I've actually got a little bit more information on. Basically what we have here is a photographer made this book, and I don't know how he pronounces his name, C-A-R-I-O-U, we'll call it Caravaggio, created this work, and it's kind of interesting. So what happened is that Prince took images from the book and modified them. So here's the original one. He clipped and pasted in a guitar. He put a couple of little dots of color over his face, and so then that was his version of it. So the reason all this comes to light is because the original photographer of the book, so this Caravaggio, decided to have a gallery exhibition in support of his book. And so he had everything all set. He had the pictures made and all that. And then the gallery dropped out. They said, well, now we can't do this now because Richard Prince is doing an exhibition of this work, and there's no way we can compete, basically. And so he brought suit because not only was Richard Prince using his work without permission, it was costing him money. And of course, as an artist, then you need to be able to make your money. So so here's the verdict. So the arguments that were brought forth with Prince was that it was a fair use. It was criticism. Oh yeah, that didn't work. It was comment. No, that didn't work. Obviously, it wasn't news reporting, teaching, scholarship, or research. Prince's failures here is he didn't use the work as social commentary against the original images. He intended the works to be used for financial gain. 8 of those paintings sold for combined almost $10.5 million. That's a boatload of money for taking somebody else's work, pasting on a picture of a guitar, which, oh yeah, that was also copyright infringement, and painting a little bit in the eyes. He acted in bad faith he actually had the nerve to ask the book publisher for multiple copies of the book without telling him the plans so that he could use that in his own work. His work had a direct negative impact on Caravaggio's ability to profit because his own gallery show was canceled because of Prince's gallery show. Anyways, obviously this is an older slide. The hearing was scheduled in May of 2011 to determine damages, and it came out to Prince's loss out on that one. Cindy Sherman, she's a photographer. She's made a career out of doing self-portraits, and originally it started off, her big break was she did these untitled film stills where she would dress up as kind of a stereotypical woman from like the 50s kind of era. And all of those photographs were not based on any particular film, but it was kind of a genre. And so because of that, that was very clearly her own work. So here, what she followed up in, and this is one of her later series, is she created work, also self-portraits, based on some of the original Renaissance masters. So here's her photograph. Here is Caravaggio's The Sick Bacchus, and you can see, obviously it's a mirror image, but they both have the white toga. They both have grapes on the table. They both are holding some grapes, and so very, very clearly similar. Now, would this be considered a copyright infringement? Maybe, maybe not. So, well, definitely not. If the instead of Caravaggio's Sic Bacchus, which is obviously well before current copyright laws existed, if this was based off of something that was made today, then maybe or maybe not. Chances are it would still be okay, because you can't copyright the idea of this, and so this is her interpretation, and it's a completely separate entity. So hopefully that makes some sense to you. One of this whole concept here was very recently upheld, in that it would not be a violation, and the interesting, and I should have added this to a slide, but this was just April of this year, where there was a case with a girl who was kidnapped by her father, taken out of the country, and this is a pretty famous case back in the I guess the girl was kidnapped in 2007 by her father. And so before she was kidnapped, there was a picture of the girl. It was taken on Palm Sunday. She's riding piggyback on her dad's shoulders. They're standing in front of a church, and they made this into a TV movie. So the story, obviously not the picture, but in the real life events, the FBI used that photograph that somebody had taken of the dad and the girl in front of the church, and they used that for the wanted signs and for the missing girl signs. And because the father was actually a famous socialite person, the photographer is actually relatively well known, and so it's not like this was just a family snapshot. And obviously they don't make TV movies based on unknown people for the most part. But anyways, in the movie, they basically reproduced the scene. So you have a picture of a man with a little girl on her shoulders, and he's holding something in his hand just like he did, but the background is different, and the style, the way that the image is stylized is completely different. And the original photographer of 2007 filed suit saying that he was basically ripping him off, and the court said no. Obviously there's similarities here, but you can't copyright an idea. And so the idea of a girl riding piggyback on her dad's shoulders with the dad holding something in his hand is too vague. And so in that way, the Cindy Sherman here, even if this was a contemporary photograph or painting instead of one made in the Renaissance, then this would most likely be okay. Another interesting one here. So the big earthquake in Haiti, there was actually a photojournalist down there when it happened, and so he, in the mayhem, immediately following, took some pictures and he posted them on Twitter. AFP, which is the big French news agency, posted them, and they took credit for them. They didn't pay for them, and basically the original photographer said, hey, you know, what the hell, that's my work and you have no right to publish that without giving me credit for it and without paying for it. And they said, well, hey, it was on Twitter, and you know, TwitPic, which I don't think they even have anymore, but they said because it was retweeted, they used a retweeted version, and so they didn't know it was Morel's work. Well, that's not exactly true. They actually, there was proof that they tried to contact him before running the image, but they couldn't, so they ran the images, giving it credit to the guy who retweeted them. They said, oh, hey, Twitter's terms of service, which is actually notably different from TwitPics, was that once it's on Twitter, then they have the right to reproduce it. Well, you know, the problem with that is that, yes, for these kind of social media sites, they can be reproduced, but the idea is that they're reproduced on, you know, Twitter, or if you posted it to Facebook, it would be reproduced on Facebook, and that sharing isn't extended to people who take images off of those sites. Eventually, he sued all of these people because they all ran his picture, and even though AFP was the primary target, you know, ABC had settled, and basically he was then countersued by AFP for aggressive assertion of rights. Well, that's just ridiculous. That's just a way of trying to muddy the water, trying to get him to back off because he couldn't afford a long legal battle. Anyways, battle's still ongoing, and very, very likely this is going to end up in the original photographer's favor. Pilfered magazine, based very short lifespan, was encouraging people to submit work of their favorite visuals pilfered from the web to share with one another. Very, very clear copyright infringement, and they didn't even make it 3 months. Another example here, basically a book author, Pulp Fiction, wanted to base his, I think this is the original, this was the one that was used, wanted to use basically the same idea for a picture for a book cover, and didn't want to use the original artist that created it. And so they created it cheaper by somebody else. And when the original author replied, or said, "Hey, what are you doing? You're stealing my work." The response from the creative director was that inspiration can come from anywhere. We were inspired by your technique, just as you were inspired by other artists who painted the original pulp novel covers. So nobody's stealing anything from anybody. Now that's a real bastard kind of response. But as you can see, and how we kind of discussed with the previous examples, it's not the same, and you can't copyright an idea. So even though it's a shitty thing to do, probably not copyright infringement. Here's the entire essay for you, and I'll just leave it there for you to read for yourself. So as you can see, definitely some bad blood there, and Alan's response here was that he's using the internet to shame these people, and in electing not to fight this infringement, probably very wise, because it was something that he's got very little chance of actually winning. Again, showing the ideas. Here's the original. Here's somebody else went to the exact same spot to photograph it. Very, very similar. Obviously, it's different time of year. He did it multiple times from multiple locations. Definitely a shitty thing to do. But again, you can't copyright the idea. And so, even though this seems to be kind of a lousy thing to do, it's really probably not infringement. Here's a local sort of one. If you've been to Seattle, in front of the Seattle Symphony, they have a brass sculpture here on the ground, and somebody had originally infringed upon it, and at that point the sculptor, the creator of this, had went ahead and registered their work. And so the original infringement, he got a $1,000 settlement in small claims court. Come to a little bit of time has passed, and then a photographer comes and he photographs somebody standing on two of these footprints, and he sells it as stock photography. Now, because at this point it has been registered with the Library of Congress, he sued, and the photographer ended up settling for an undisclosed amount of money. The stock agency that was selling the photograph, Mackie settled for an undisclosed amount with the stock agency that was selling the photograph, and he's still suing the photographer here, and it's an ongoing case. So tools to protect your copyright: you can register your work with the Library of Congress, use metadata. These are things that metadata is something that's built into the image. So if you're taking a photograph, you can embed your contact information, all that kind of stuff. Put contact information on images and on text, or pretty much anything that you create. There's different tools for finding these things. This is more for visuals, but can absolutely be helpful in helping to find multiple copies of photographs or paintings or something like that. So I'm going to leave it at that. Hopefully you get an idea that this isn't something that's just a black and white sort of thing. Copyright's important. It's very relevant in today's world, especially with sites like Facebook and Pinterest. Whenever you sign and agree to those terms of service, you're basically saying that those sites are not going to be liable for things that you post, even if it's not legal for you to post them. Basically, all of those terms of service kind of hang you out to dry. So if, for example, you post a video of a music video on your page, and you didn't have permission to do that, then you would be specifically in trouble for that, instead of any of those websites, social media sites. So anyways, hopefully you found this somewhat interesting. Definitely is relevant on a day-to-day basis. It's really impossible to go through a day without interacting with some piece of data that is protected from copyright, whether it's art or whether it's technology or anything like that. If somebody came up with it, architecture, all of those things. If somebody came up with the idea, then input that idea, implemented that idea in some way, then it's going to be protected. And it's best to ask permission before using those kinds of things. Let me know if you have any questions. We're going to leave it here, and next week we will we'll kind of branch off in a completely different